perfect time to talk about this because, after last weekend with Thanksgiving and then upcoming holidays as well, this is when we tend to spend the most time with our family and really notice that, things are different than the previous months or the previous years that we've sat down and talked with those individuals, or if it's been a while, and that change can seem more drastic. But it's also the perfect time then to talk about what they have in place, what documents they have in place, and also what abilities you would have to be able to help them if they needed it. So before I go into too much detail on that topic, just a couple of housekeeping things. As always, you can send in questions through the Q&A function, and I'll see those pop up. So if you have any come up about, your situation or like some concerns about anything, and you have questions that you want answered about this topic, please feel free to submit that. And then at the end of this, you'll also receive a couple of different things from us. One is our chart on activities of daily living. Activities of daily living are the things that are used to determine the types of care that someone might need, and also can be used in regards to when a long-term care policy that somebody has, when that comes into effect as well. So that is a chart that you'll get from us, which can be pretty helpful. And then also you'll receive a feedback form as well. That gives you a place, of course, to give feedback, but also a way for you to let us know that you'd like to have time set up with one of our attorneys to talk about your situation or your family's situation. All of our initial consultations are complimentary. We schedule them for about 2 hours. So it doesn't cost anybody anything to come in to talk to us, but usually by the end of those 2 hours, we can give you a pretty good recommendation of what you should do in your situation or your family situation, what we would recommend putting in place, and then what the cost of that planning would be. Again, to get started, we're talking today about, noticing changes and, when to, kind of decide what your next steps might be for that loved one, especially if you've noticed declines in capacity or just health in general, or that they seem to need more assistance than they did in the past. So when we're talking about, noticing these changes, what do we mean by things that you might be looking for? Well, one, of course, with health might be, does there seem to be a mobility change? Does there seem to be other changes that are making, them living alone harder? Are they having more trouble getting up and down the steps? Do they need do they have everything available to them on one level as opposed to, 3 or 4 different stories, right? Really 3, I guess, if you got upper floor to the basement. But, if things are all on different floors, but they're having trouble getting up and down those steps, that's, a potential hazard for them. So you want to be able to know when it's time to maybe have the discussion of, is this the right place for you to live anymore? Or are there other things that we can do to help make this easier for that person? That's part of this discussion, of course. Another part of it is one of decision making and like financial side of things. So when we're talking about things like, do they seem to be forgetting paying the bills? Do they are they making financial decisions that are different than they might otherwise make, or had made in the past? Has there been some sort of change in that you've noticed? And what do they have in place for you to be able to step in and help when they need it, right? So once you've noticed these changes, what do you do next? First and foremost, have the discussion with that loved one to see what types of documents they have in place, like powers of attorney for finance or powers of attorney for healthcare. What do they have in place regarding that, those types of documents? Because those are the documents that are going to grant somebody the authority to act on their behalf. So if they have those documents in place, ask to see it, take a look at them. And especially if you are the person named as that agent, it's really important that you take a look at them, because they will tell you what you're able to do for somebody. With financial powers of attorney, for example, they're really only as helpful to you as the express authorities that they grant to you as an agent. If they don't mention something, if they leave something out entirely, related to a decision, you won't have that authority to act in that way. If it's vague, the way it's written, that could be a concern as well, because then it comes down to who's interpreting this, right? Does the person across from you read that the exact same way you do? So to give you a hard example of what I'm talking about, or a more solid example, the state statutory form in Wisconsin has basically one word authorities that it grants. It will say things like, I grant my power of attorney for finance, my agent under this, I grant them the ability to do banking or to do business, right? That's very unclear how far that authority goes based off of that one word. Now, there is more information on that in the actual statutes that form is based off of. But the problem is when you're dealing with somebody who doesn't know those statutes, doesn't read them on a regular basis, which is most people dealing with the power of attorney, they may interpret that one word differently than you do. So with banking, does it include the ability for that person to set up new bank accounts or just deal with the current bank accounts? Can they pay bills based off of that authority? Can they move accounts from one institution to another in order to maybe maximize the interest that somebody's getting? That's really unclear based off of that one word. This is not a document where being broad in your language is actually helpful, because it can be very concerning when you actually need to act if that person across from you, like I mentioned, is actually going to honor that document, the authority under that document. So seeing those documents can be really helpful. But in addition to just standard decision-making authorities for like paying bills or moving bank accounts, making those sorts of decisions, with financial powers of attorney, it's also really important for you to know whether or not it allows you on behalf of your loved one to make decisions related to like planning around long-term care expenses. And this is not going to be an authority that just says my agent can plan around long-term care expenses. At least I've never seen it written that way. But you'll see usually a collection of authorities that you would want in that document in order for you to be able to do that. It doesn't mention anything about gifting. And I'm not saying gifting in the like charitable sense here, just can you as the agent on behalf of your loved one gift money from one person to another? Are there limitations on those gifts, right? Are you limited to a certain dollar amount per year, which you'll often see it's the annual gift tax exclusion, right? But when it comes to long-term care planning, do you want that limited? Oftentimes that limit can be a limit on how much you can potentially protect for somebody. So with gifting, you might want it to be unlimited. Can you, on behalf of your loved ones, set up certain types of trusts for them? Can you file Medicaid applications? Things of that nature. That's really important for you to know. And I'm not saying you yourself have to look through this and understand all of that, but if you are able to, with your loved one, have it reviewed by their attorney or with an attorney that you're taking them to who focuses their practice on estate planning and elder law and can give you a good recommendation of, hey, here are some gaps I'm seeing in this document. And while this might not be a problem now, it could be down the road if you need to do X, Y, and Z. Very commonly, the biggest gap we see in those documents is related to long-term care decision-making, whether or not they can make the gifts, like I mentioned, at all, or they're limited in the amount, or whether they can set up certain types of trusts, or whether or not they can, file a Medicaid application, for example. So a lot of times, even in the statutory form, there's the ability to file an application, but I've seen some in the past that were written by attorneys that did not include the authority at all, and that's concerning, because who does file that application then, right? So look at the document they actually have, in addition to knowing whether or not they have one at all, because not all powers of attorney are created the same. So a lot of times people get a false sense of security over, well, hey, I have a power of attorney for finance, so therefore I'm fine, or I'm covered. Well, not necessarily, and probably not in the same way that you think. So it's very important to have it looked at by somebody who knows what they're looking for. And that's where that estate planning attorney or elder law attorney can really be helpful with that, because they know what they should be seeing in there in order to actually tell you, hey, this is probably what you need, or there are some gaps in this that we would want to add and fill in those gaps. So, with financial decision making, that power of attorney for finance is really important. You also want to know when that document allows you to act. Does it require a declaration of incapacity for finance, or is it immediately effective? Can you help them now, right? And that whether or not you need to be able to help them now is going to depend on the individual. Sometimes people have capacity still. They have the ability to act on their own, but maybe they just need a little bit of assistance. Maybe they want assistance. And that's where that can be really helpful to have that immediate authority on a financial power of attorney. When it comes to healthcare decision making, do they also have a healthcare power of attorney in place? How long has it been since they've had it in place? Do you have HIPAA access under that document, or an additional HIPAA authorization? So if you're listed on the healthcare power of attorney, you still want to be able to talk to the doctor, right, and be able to get information. A lot of times people have their healthcare power of attorney in place through their doctor, their physician. And so that would be a place to look if you don't know, if they have one, and if you have HIPAA authorization on file with that doctor as well. If they've already signed that, they should be able to give you that information. But, if they have an additional copy at home, it's good to take a look at. When it comes to healthcare powers of attorney and noticing that your loved one might be declining or that they might need additional assistance, one of the most important things to look at when it comes to care decisions is whether or not you can admit that person, that loved one, as their agent, whether or not you can admit them to a care facility. A lot of times on that state statutory form, it's a yes or no question, checking the box, right? Not always. If it was written by an attorney, it might not be written that way. It might just state in there whether or not that person can. But on the state form, the most common one I see from doctors' offices, there's a yes or no question. And this document, if they've marked no, that my agent may not admit me to a long-term care facility or admit me to a nursing home, that's not a decision they have. You can have a lot of problems when that time comes that decision has to be made. Because if that is not an authority granted to the healthcare power of attorney agent, but that's the type of care that person really needs, in order to get the authority that person needs to be able to admit them to a facility, they have to go through guardianship to get it. And that is an additional process that now that person has to jump through hoops to be able to just help their loved one. I, talk to so many of my clients who, say, well, I don't want to ever be, in the long-term care facility. I don't want to be in a nursing home. I'll stay at home as long as I can. That's a great, plan if it's workable. Nobody really wants to leave their home, right? It's their home. It's where they're comfortable. But if you don't have that authority granted, and that's where you really do need care, your agent is going to be in a lot of, they have to jump through a lot of additional hoops just to be able to provide safe care for you, right? Because at-home care, while it's always an additional, choice that somebody can make to bring someone into the home and provide care at home, that can also be the most expensive type of care that person would receive. It's, hourly as opposed to daily or monthly care. But, assisted living, skilled nursing facility can range anywhere from, $4,000 to $5,000 a month on the low end, maybe up to $9,000 or $10,000 on the upper end per month. Whereas the at-home care might be $30, $35 an hour, right? So it sounds a lot cheaper initially until you start to realize that, well, hey, if I need the type of care that I would receive in a long-term care facility, I'm going to be paying more money at that hourly rate than I would just going into a facility. So people with limited funds, at-home care is not the perfect solution. It sounds like it might be. It might be initially, and it might be until they pass away. It depends on their needs. But it's if they actually need assisted living or skilled nursing type care, at-home care is going to be easily the most expensive. So if you don't have the ability to admit them to a facility like that, and you're stuck with only being able to bring in somebody to the home to provide at-home care, but they have limited funds, this could be a choice you have to make of going through guardianship to get that authority. So when you're looking through the healthcare power of attorney, knowing whether or not you have the ability to actually admit your loved one to a care facility, whether or not that's the goal, you want to have that authority. It's very rare where there'd be a reason of marking no on that. I mean, it's up to the person, right? It's their wish that they mark it how they want. But in general, from the just practical side of it, you're not really preventing anybody from being able to admitting you to a long-term care facility. You're just making them jump through more hoops to do it. And I've had clients who say, well, then so be it. Not my recommendation, but it's up to the person. So maybe if you're looking through that healthcare power of attorney while you're having discussions about potential care needs or assistance needs with your loved one, look at that and explain to them, hey, I see that you marked no on this, but do you know that this can cause this problem potentially if it's needed? And, explain that you're not trying to, throw them into a nursing home right away. You're not trying to take that decision away from them, but you're just trying to provide flexibility and the least amount of hardship possible when that time comes. Because as hard as it is when somebody doesn't want to go into a care facility to make that decision, it's a lot harder if you have to go through guardianship first, right? That's never a process that somebody wants to go through. So speaking of guardianship, when it comes to long-term care decision-making, if somebody doesn't have these documents in place and you're concerned about, cognitive decline, capacity decline, how do you make sure that you have the authorities you need to step in on behalf of your loved one? Well, if the person still has capacity, even if there's the start of a decline, what you want to do as soon as you can is sit down with an estate planning attorney, sit down with an elder law attorney, and try to get those documents in place for that individual, because once they've lost capacity, where if an attorney wouldn't feel comfortable with them signing anymore, the only way to get the authority to act over a loved one, if they don't have powers of attorney in place, is to go through guardianship. And so if you're unfamiliar with the guardianship process, it's essentially, usually in the long-term care context, not talking about like when children with special needs or disabled adult children where they need their parents to still act as guardians after the age of 18. That's, it is a guardianship process, but the reasons behind it are obviously a lot different, and that's an entirely different discussion. But when we're talking about, like elderly loved ones who might need guardianship, or incapacitated loved ones who might need guardianship, if you have good powers of attorney in place, you can generally avoid that being necessary. But if they don't have the ability to sign new ones at that time, and they don't have any in place, or they have very limited ones in place that don't grant you the authorities that you would need, the only way to get that authority is to petition the court for guardianship over them. And so that usually involves the family hiring, one attorney at least to petition the court. That's usually how that works. But the court will also appoint what's called a guardian ad litem, who is another attorney. That guardian ad litem is somebody who's there to make sure that the person that is the proposed ward, that they actually need guardianship, that somebody's not trying to, abuse their loved one, or commit elder abuse, right, or take advantage of anybody, or that the person that's being named as guardian is the right fit, right? So there's always going to be at least the guardian ad litem involved, but there's usually at least two with the family hiring one to help. However, where things get complicated is when the loved one, especially if they don't understand what's going on, they contest that guardianship at all. If they say, I don't need a guardian, what's going on? Why is this happening? Right? The court may appoint a third attorney to fight against the guardianship on behalf of your loved one. Or if another family member contests something, right? So potentially here, if things are not going smoothly, you might end up with 3 different attorneys involved, a pretty contentious situation of having to prove that your loved one doesn't have capacity, in a courtroom under oath, right? On the stand, so to speak. And somebody's going to be fighting against it, and it can be contentious. So most people don't want to have to go through that when they're just trying to help their loved one, but it might be what's necessary if those documents aren't in place. And to go through all of that, not only can that be expensive, but it takes more time just to be able to help that person, right? And most people are not trying to go through this process to cause harm to anybody or take advantage of anybody. Most people are truly doing it to try to help the person. But if they have good powers of attorney in place for finance, for healthcare, if those documents allow that person to do what they need to on behalf of their loved one, it might ultimately be an unnecessary step. And in most cases, it is unnecessary, even when that person has lost capacity at that point. If the documents in place allow those authorities, or grant the right authorities to the agent to be able to do what they need to, the guardianship process is ultimately going to be unnecessary. Now, that doesn't mean that somebody might not end up there anyway, because with powers of attorney for finance, for example, and this is something that you can do from a practical standpoint for your loved one. Powers of attorney for finance don't stop the person from acting on their own behalf, right? It's like sharing authority with somebody that you've chosen. So with loved ones who may not be realizing that they're declining cognitively and are spending money in ways that they wouldn't have in the past, or are being more irresponsible than they would have in the past, powers of attorney for finance don't stop that person from doing that, right? They just grant authority to someone else to also be able to act on their behalf. So if they're causing financial harm to themselves or to their spouse, right, or to another loved one that they're taking care of, because they're making bad financial decisions that they wouldn't have made otherwise, no power of attorney is going to stop them from doing that. So that is where, from a practical standpoint, if you've noticed these things happening, you can always try to do things to prevent that harm, right? For example, clients who maybe are maxing out credit cards, right? Maybe cancel the credit cards and make sure that they're not able to do that anymore, or limit their access to being able to apply to new ones, like freeze their credit, right? But if you can't stop that, if you've gone through all the practical things that you can do to stop someone from causing financial harm to themselves, then that's where sometimes guardianship is still necessary, even with a power of attorney in place. And part of the reason for that is because with guardianship, whereas a power of attorney is not taking authority away from the person themselves, it's not shifting anything away from them, it's just duplicating the authority to someone else that they already have. Well, if that's not going to stop them, guardianship can stop them from causing that harm to themselves. And that's because guardianship is actually shifting rights over those decisions from one person to another. So this is both why you generally would, if you can avoid guardianship over a loved one in this situation, ideally you want to, because that's a pretty extreme decision to make, right? But if it's the decision that truly protects them the most, even with the best power of attorney in the world, maybe it's a decision that needs to be made. Now, thankfully, that's rare, because most of the time you can do other, like I said, practical things to stop that harm. But it's important to know that, if you notice these changes in somebody, you have concerns about them causing this potential, risk to themselves or harm to a loved one, especially like spouses to one another, it's something that you need to be aware of as an option. So when you're noticing things that are changing, looking at their past financial management is of course important, because some of this might just be, if somebody's always been not really great at financial management, that change or that continued lack of financial management skill is not necessarily going to be a reason to go through guardianship or to have a power of attorney take over for them, right? It's just, maybe they've always been bad at it. But if it's a change that you've noticed where, hey, they used to be just fine managing this, but now they seem to be forgetting these things, or they seem to be, not taking care of themselves financially the way they used to in the past, and this seems like a concern, that's where you sit down with the discussion and say, hey, I have noticed these changes and I'm concerned, right? And if you don't have a power of attorney in place, let's talk about getting one in place. If you do have one in place, let's take a look at it and maybe have an elder law or estate planning attorney review it to make sure that it's what you actually need. And if we have all that in place and that takes care of it, then great. So yeah, looking at what types of powers of attorney that person has in place, if they have them in place, and if they do, what those actually allow you to do on their behalf is a really important step when you've noticed things are changing. It's probably one of the most important steps from the legal side of things, of how do I take care of my loved one? Because there's a lot of, if you have a good power of attorney in place, it allows you to do a lot of things that you might need to do down the road to help them as well. So, if they have the ability to get that in place now, that can help you be able to take care of them down the road when things maybe get worse in terms of capacity or their health declines further, right? So, it's one of the most, if not the most important things to look at when somebody has concerns about care coming up in the future or declines in health or capacity. It's one of the first things we try to get in place for somebody if they don't already have it in place or don't have good ones in place, right? Don't have valid authorities in there that we would, or not valid, that's not the right way to put it, but don't have the authorities we'd want to see in there that will help them the most, right? So yeah, Once those are in place, though, if you're still looking at, what do we do for care if that's necessary, understand that you try to get an understanding of what their care options are, right? So I've mentioned a couple of different things with like at-home care or assisted living, skilled nursing, right? Those are kind of the three big umbrellas for the types of care that somebody might need. But if you don't know what type of care they would need, thankfully, there are professionals out there who can help you figure that out, right? There's care management organizations that can help you find the right facility or the right situation for somebody, because maybe they have an analysis done on that person where it's, hey, at-home care is not going to be the best option for them, or it's going to be the most expensive, right? And once you find the right care that person would need, another really important thing for you to be aware of is not just, is this the right place in terms of the type of care that they need, but also look at the financial situation of your loved one and what the cost is to be there. And not just what the cost is, but how long is that facility requiring that person to pay out of pocket before they can live there once they've run out of assets, right? So once somebody's run out of assets, that's when you're generally looking at Medicaid, right? Or when they've spent down below the Medicaid limits, which vary depending on whether you're married or single. But, once they've spent down below those Medicaid limits, will that facility allow them to continue to live there? Does that facility accept Medicaid at all? Some don't. So it's really important for you to know, hey, if this is a private pay only facility and my loved one is not going to be able to do that indefinitely, maybe that's not the right place for them, because that would require them to potentially move once they do run out of money. With the private pay requirements, you tend to see anywhere from like 1 year private pay. I've seen 2 years pretty consistently at this point, and then sometimes even 3 years of private payment for that facility before they'll let somebody live there once they've spent down to the Medicaid eligibility requirements. And knowing whether or not that person, your loved one, can meet that requirement is important, because you don't want to have to move them at that time if that's a good facility, if it's the right fit for them. How do you determine whether that's doable for them? Well, that's also where you can sit down with an elder law attorney who can really tell you and do that analysis and say, hey, this is this is how you would do that, or it's an option for you, or it's not, based off of their assets, income, and the cost of care. But yeah, you can look at what that cost of care is, their income, being subtracted from that, of course, and then based off of that shortfall, how long is that going to last? How long is what they have going to last? And do they have the liquidity, possible to do that? So that's also where having an elder law attorney give you that analysis can really help you out, just so that takes it off your plate, and they can really tell you whether or not this facility is a good fit or not based off of that type of thing, the cost component. And once you've met that private pay requirement, and maybe somebody is on Medicaid, do you have other options in place to, maybe provide supplemental payments for things that Medicaid might not cover for them, right? And that's, again, where the elder law component comes in. Another thing for you to talk with them about too, before you get to that analysis, would be, talk with your loved one and see if they have long-term care insurance. Long-term care insurance is different than like disability insurance, by the way, where like, hey, I'm unable to work, so Aflac pays for my care, right? But long-term care insurance usually covers at-home care, assisted living care, and skilled nursing care. It usually, these days anyway, you'll see a maximum amount per day that it'll pay out, a maximum total that it'll pay out, or a maximum time frame that it'll pay out. So it usually doesn't, for most people anyway, when they're getting these policies, it doesn't always cover everything. It won't cover it indefinitely. It depends on the policy, of course. You see some very old long-term care insurance policies that pay, crazy amounts of money out indefinitely. There's no maximum. And to those people who have those policies, I would say do not get rid of it. If it's expensive, that's still well worth it. But you're not going to find those policies anymore. But if your loved one has long-term care insurance, that can be really important for you to be aware of, so that you can get a sense of what do we have as an option to help pay for care. If their income alone wouldn't be enough, do we have this supplemental source of payment to help get through a private pay period? Are they ever going to need to be on Medicaid if it covers, indefinite amounts, right? It's just good to be aware of, so that you know what your options are. So ask that question. Even if you're not noticing a decline in your loved one, but you know that you'd be the person in charge of making that decision at that time of, whether or not to look at care, take a look at, and you sit down with them over the holidays and say, hey, do you have this type of product? Do you have this type of, insurance in place? Because it'd be helpful for me to know if I need to make that decision for you, right? If somebody's past their mid 60s, it's probably past the point where they can really get an affordable policy at that point. Usually it's by your mid to later 50s is a good time to look at it. They can not be able to get this insurance due to their pre-existing conditions, right? Somebody's been diagnosed with Parkinson's, been diagnosed with Alzheimer's, they're unlikely to be covered by this. If they already have it in place, that's different, but they'd be unlikely to be able to get it if they don't. And I'm running out of time here, so I'll wrap up for everybody. But so just to recap here with everybody, sit down with your loved ones, talk about what documents they have in place related to powers of attorney, talk about long-term care insurance, see if they have it, and try to take a good look at, are they declining in sorts of capacity or their ability to do things that physically that they used to be able to do. And of course that happens as we age. Just to let everybody know, next week, we actually have our in-person public seminar in Appleton at the Bordini Center through Fox Valley Tech at 2 p.m. and 6 p.m. And you can sign up for that at estateplannинglive.com. So if you're interested in hearing us talk about wills, trusts, powers of attorney, Medicaid again, and more in depth than today, that's a really good source of that information if you want to come and listen to us speak. So I'd encourage you to sign up for that if you're interested. And then the following week after that public seminar, we're actually going to be talking more about Medicaid itself and alternatives to Medicaid to help pay for care. So that'll be the same time as this webinar, but so same way you signed up for this one. And again, keep an eye out for that chart on activities of daily living coming to you, and also the feedback form where you can let us know whether or not you'd like us to reach out to set up an initial consultation with you or your loved one. And again, those are complimentary. They don't cost anything to do that. And we schedule them for about 2 hours. So with that, I will let everyone go enjoy the rest of your day, and I'll stop talking and, have a, Merry Christmas, good holiday season and all that. And we will see you guys